Madam Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, hearing of the appeal in CCJ Appeal BZCV number 2 of 2022 between Jeffrey Sersland, MD, Seferino Paz Jr., and St. Matthew's University School of Medicine Limited. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Madam Justice Rajnat-Lee.
Good morning, everyone.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamadar.
Good morning, everyone.
May we have the appearances, please? Thank you.
Good morning. May it please the court, Nadia Chiesa and Daryl Bradley appearing for the appellants, Jeffrey Sersland, MD, and Seferino Paz Jr.
Yes, good morning again.
Good morning, Your Honors. If it pleases the court, Eliana Swift on behalf of St. Matthew's University School of Medicine Limited, the respondent.
Yes, good morning, Ms. Swift. Ms. Chiesa, are you ready to make your submissions?
I am, thank you. This is an appeal today against a judgment from the Belize Court of Appeal dated November 27, 2018. And for your reference, the appeal judgment is found at page 7 of the filings. And this is an appeal which arises from a claim by the appellants, Dr. Sersland and Mr. Paz, for a claim for the appointment of an inspector to investigate the affairs of the respondent, St. Matthew's University School of Medicine, pursuant to Section 110 of Belize's Companies Act. The trial, which was concluded in April 2016 in front of the Honorable Justice Abel, was successful, and the appellants were granted the relief they sought and an inspector was appointed. St. Matthew's University then appealed, and on appeal, the trial judgment was set aside as the Court of Appeal found that the appellants did not meet the 10% shareholding threshold required to have standing to bring the application. And at its crux, today's appeal deals with a quite narrow issue. It comes down to whether the appellants held sufficient shares in the respondent company to have standing to apply for the appointment of an inspector pursuant to Section 110. And as I noted, the trial judge found that they did have standing and went on to consider the other branches of the test for the appointment of an inspector, while the Court of Appeal found that the appellants did not have standing and stopped the analysis at that stage. We don't propose to spend a long time reviewing the facts, as they have been summarized quite succinctly in the appeal judgment. However, it may be of assistance to highlight for the court some of the key factual findings which underpin our appeal today. And these are the factual findings which really demonstrate the pattern of conduct by the majority shareholders, which towards the minority shareholders, which are directly related to the circumstances giving rise to the underlying claim for the appointment of an inspector. And so the appellants are minority shareholders in the respondent company, which was incorporated in 1997. It was incorporated to open and operate a medical school in Belize. Shares were allotted to the appellants at the outset, and the appellant, Dr. Sersland, was a founding shareholder and very involved in management and operations of the company. By December 2000, the appellants together held just over 35% of the total shares issued in the company. After this point, as set out in the facts found by the trial judge and the Court of Appeal, you'll see a fairly classic pattern of conduct of oppression and unfair prejudice towards the minority shareholders. The appellants were locked out of the offices. The majority shareholders changed the signatories on the company's bank accounts. and obtained a without notice injunction against Dr. Sersland, barring him from the company's premises. The majority then went on to file a list of directors, which excluded Dr. Sersland, who had previously been a director. On November 27th, 2001, the majority called and held an extraordinary meeting of the shareholders of the company. It's the appellant's evidence, and it was a finding of the courts below that the appellants didn't receive notice and didn't attend. And at this meeting in November 2001, the majority passed resolutions substituting and introducing a new memorandum of association, and most critically, increasing the respondent company's share capital from 50,000 to 1 million. A few months later, in January 2002, the majority obtained a court order which confirmed those resolutions. Again, this was a step taken without notice to the appellants.
Just stick a pin there. Why was it necessary to obtain a court order to approve the resolutions?
There's no evidence in the record as to why that step was taken. At trial, at first instance, the defendants or the respondent today did not file evidence as to why that court order was obtained.
And is there in this record, in the record before us, any evidence of the application that was made and the evidence in support of the application?
No, we have a copy of the order, but not a copy of the application that was made. And the order can be found at page 576.
I know that, but I'm more interested in the application and the evidence supporting the application. And I was very disappointed that that did not form part of the record.
I don't believe it was in front of the court at first instance or the Court of Appeal. And so it didn't find its way into this record today.
Yes, proceed.
Thank you. So following on that January 2002 court order that was obtained, the majority then called a shareholders meeting in early February 2002, where they passed resolutions to allot and allocate those newly
I'm sorry, I have to interrupt you again. Yeah. I'm still processing our last exchange. Who introduced the order in the trial court? Which side?
It was introduced by the respondent, St. Matthews, and it was attached or exhibited to the second affidavit of Lisa Parafit. And it was the only substantive affidavit filed by the respondents. There was a first affidavit of Ms. Parafit, but that was on a preliminary issue.
Okay.
And I don't believe the court order is alluded to in the claim, the underlying claim and the supporting affidavits, but the order wasn't exhibited and the application not exhibited there. Obviously, the appellants didn't have notice of that application. It was introduced by the respondents at first instance.
Yes, go ahead.
Thank you. So I was just saying that in February 2002, the majority shareholders of the respondent passed a resolution allocating the new shares, the 950,000 new shares that had been increased in the fall. And that resolution provided that the increased shares would be offered to members, except those whose conduct has been contrary to the best interests of the company. A month later, in March 2002, the respondent allotted those increased shares, the almost 950,000 shares, to a Cayman company called St. Matthew University School of Medicine, open bracket Cayman, close bracket Limited. So very close to the name of the company that was operating in Belize, and that's the respondent before the court today. After allotting those new shares to the Cayman entity, the majority then proceeded to dispose of many or most of its assets in Belize, closed its operations and office in Belize, moved the medical school and its operations, including its students, over to Cayman, where it continues to operate. And so it's in the context of these facts which gave rise to the appellants seeking relief from the Belize court and ultimately commencing the claim that brings us to today's appeal. I propose now to move on to the grounds of appeal. And while the notice of appeal did set out several grounds of appeal, as the court will see from our written submissions, we have condensed it or narrowed it to 4 grounds of appeal, and those are the grounds I propose to address in my submissions today. The first ground of appeal is whether the Court of Appeal erred in its interpretation of Section 110 of the Act, and more precisely Section 110(1) sub B. The second ground of appeal is whether the Court of Appeal erred in setting aside a discretionary decision of the trial court. The third ground is whether the Court of Appeal erred in its consideration of the question of standing. And lastly, whether the Court of Appeal failed to give adequate consideration to the weight of the evidence before the court below. And so I don't propose to repeat what's in my written submissions, but rather I'll go through the main points for each of these grounds and answer any questions.
Ms. Shazier, before you
Yes.
move on the facts, the fact narrative that you've outlined for us, to what extent was it disputed, if at all? I think you've said these were the findings of the trial judge. Is that right?
That's correct. They were the findings of the
And
trial judge.
did the Court of Appeal support those findings or in any way suggest that the findings of fact were faulty?
No, the Court of Appeal fully accepted and endorsed that finding of fact. The narrative I've presented to the court today actually comes from and follows the narrative set out in the judgment. And
so that's why the first part of the question is really to what extent were these facts disputed by the respondent, if at all?
They were, I would characterize it as minimally disputed.
But the notice point was disputed, right? There was a dispute as to whether or not notice was given at the 3 stages. That is to say, I think the 2001 meeting and so on. Is that accurate, that the respondents assert that there was due notification?
It was certainly argued in my friend's responding submissions. I'm looking at the affidavit that was filed, and just so I can answer the question accurately, I'm looking at that second affidavit of Ms. Parafet, and it does not address in it the issue of notice being sent. I know the company takes the position that notice was sent, but that seems to have been raised more in the latter stages of these proceedings rather than at trial.
So wait a minute. So are you saying that it was raised in the submissions, but in the face of an assertion by the appellants of fact that there was no notice, Ms. Parfait for the respondents does not respond or is silent on that, yes?
In the 2 affidavits that she's filed, she is silent on the notice question.
And so as a question of law, if there is an affidavit that asserts a state of affairs, a factual state of affairs, and it is not responded to by the respondents, what is, as a question of pure law, what is the status of those facts? Are those admitted?
The facts be admitted, and I would submit that it went one step farther than that. Not only were the facts not disputed and therefore admitted by the defendants, the court then made a finding and accepted the appellant's uncontroverted evidence on those points.
Yeah, okay, thank you.
Counsel, before you move on, Going back to the question that the president asked about the order that had been made confirming, I see the Court of Appeal refers to it at, I believe it is paragraphs 26 and 27 of the Court of Appeal's judgment. Looking at the Companies Act, I see that the company can approach the court to confirm a special resolution for reducing share capital. According to what I read in the Companies Act 48, 49, and so on, says 49 says where a company has passed and confirmed the resolution for reducing share capital, it may apply by petition to the court for an order confirming the reduction. This was, as I understand it, the question of increasing the share capital. Is it that, and this is how the Court of Appeal looked at it anyway, is there a separate provision for approaching the court to confirm that? Because that is what I'm not seeing, and I believe that's why the president asked what were the underlying papers. Because we're sort of in the dark as to what happened before that court and with what authority.
I'm not aware of a provision equivalent to Section 49 that the court just referred to. I would perhaps at the break or when I finish my submissions, I will double check and revert to the court. And I'll also look to my co-counsel, Mr. Bradley, as he may be aware. But I'm not currently aware, but we'll check and revert to the court on that if that works.
Thank you very much, Counsel.
Yes, proceed, Ms. Chiesa.
Yes, thank you. So I propose to move then to the first ground of appeal. And you'll find, as set out in our submissions, it's the question of whether the court erred in its interpretation of Section 110(1)(b). And before I turn to the provision, I think it's helpful to look very briefly at the history and purpose of the provision. And I won't repeat what's in the submissions, but just to note that this provision was modeled on an almost identical provision coming out of the UK Companies Act 1908. And we've cited from Lord Denning in our written submissions in more detail his commentary on the UK provision, which also sheds light on the Belize provision. And Lord Denning, in commenting on the background of the UK provision, spoke really about the situation in companies where it's the majority of shareholders who have the power concentrated in the hands of a few, and often the minority shareholders are left in the dark. And in certain circumstances, the majority is effectively unaccountable to anyone else because they're controlling not just what's happening, but also access to information. And Lord Denning put it this way, asking the question, who will guard the guards themselves? And he asked that question in respect of the UK provision and said it's because companies are beyond the reach of ordinary individuals that the legislation has been enacted so as to enable the appointment of inspectors. And the Belize court in the Belize Telecom case stated very succinctly that the purpose of the appointment of inspectors is to investigate the company in order to find out what has been going on. In other words, to find out facts. And that, we say, is exactly why the appellants first went to the court in Belize and asked for the appointment of an investigator, because they had learned of these various steps that started with them being locked out of the company and then proceeded to the dilution of their shares. They went to the court. Yes.
Sorry, Counsel, you've made a connection between, correct? Connection between the Belizean Act and the 1908 English Act. But was Lord Denning in the cited passage, was he speaking about the provision in the 1908 Act or a later Companies Act? The reason I'm raising that question with you is because I want you to respond as well to the second question, which is Is the mechanism of investigation in England the same as in Belize? Isn't it the Department of Trade and Industry which carries out or appoints the inspectors?
So I'm just going back to check the case. It is correct in answer to your second question that in the 1908 Act, it was the Board of Trade who's appointed to carry out the inspections rather than a court appointed.
This is crucial, it appears to me, because if you're certain that Section 110B is a shareholder's remedy, it certainly doesn't look as that is the way it is perceived in the English legislation. So why are we to believe that Section 110B constitutes the investigation a shareholder's remedy, minority shareholder's remedy?
Well, although the investigation under the 1908 Act would be carried out by Board of Trade inspectors, it is on application by a member of the company. So in that sense, it's a member or shareholder remedy. It's not the Board of Trade that decides to seek the relief. It's the shareholder who comes and makes the application.
That is one situation in which the Board of Trade can appoint inspectors, but it can do so on its own motion as well, or on the application of the majority of shareholders, or on a resolution in the company in general meeting. Don't let us. Sorry, that's not important. The question which I'm raising with you, which to me is important, is how can we interpret Section 110B as a shareholder's remedy? Because that's what you're arguing. You're arguing that the majority was, to use your words, oppressing or unfairly prejudicing the minority. And the shareholders, minority shareholders, were, by Section 110B, empowered to bring a shareholders action. This is important, I think. How do we get there with you?
Well, I think perhaps we start by taking a step back, and Belize, unlike so many of the other companies' laws across the region, doesn't have a statutory oppression or unfair prejudice remedy for shareholders. So minority shareholders in Belize start in a position where they don't have the same statutory access to remedies that, say, a shareholder in Jamaica or Barbados might have. And so there are, I've used the term oppression or unfair prejudice, not in the sense of there's a statutory remedy they could pursue, but rather it's the pattern of conduct we say is akin to that. If they had been in another jurisdiction, they likely could have sought that relief. And in the Companies Acts in several of the other Caribbean jurisdictions, they have a slightly different investigation mechanism where it could be, for example, the minister or the court on its own application appoints the inspector. So I think in that sense, the Belize Act does differ somewhat from that beginning UK Act. But in answer to your question, I think it's one of the only ways under the Act for a shareholder in Belize to actually access information about the affairs of a company if the majority won't give them that information, or if they're otherwise frozen out. So in that sense, there's not the usual shareholder remedy section we see in other statutes, but in Belize, it's one of the few mechanisms that's available to minority shareholders. And in that sense, it's a shareholder remedy.
Is there jurisprudence on this that links this section to a peg on which a minority can latch onto in order to seek and obtain relief?
So the Lopez equipment case, just to revert to the earlier question, the Lopez equipment case does set out the background and speaks about Lord Stenning's commentary and the history from the 1908 Act. In preparing for this, we were unable to find a case under Section 110 that dealt with this particular issue of the 10% requirement and the standing. The case law that we were able to find coming out of Belize.
No. I'm not so interested at this stage in the threshold issue. But I'm looking down the road. The issue of the extent to which the section can be used by a minority who consider themselves to be oppressed as a means of obtaining redress. In other words, assuming the report, the court had agreed to have an investigator, and the investigator went in and substantiated those things which you have alleged were done and which you say there wasn't any counter pleading to, and in fact which the court seemed to have admitted. What next then?
Well, the Court of Appeal does advert to this in the decision before us today. The report of the investigators is not a determination in and of itself, but it provides information to the shareholders about what has occurred in the company and can then inform next steps that they can take. And that purpose, or that effectively the end result of the purpose, the end result of the fact-finding mission of the inspectors has been addressed in, I believe, the Lopez equipment case and the Belize telecom case that we have, speaking about how those results can then be used. And so we didn't find case law that directly pegs it as a means of redress for a minority shareholder using that language, but the purpose is clear in the case law that it's to investigate the affairs, find out what has actually happened and what has happened perhaps without the knowledge of the minority shareholders, which is why you bring this in the first place. And then that information can be used by the shareholders to determine where they go from there, what proceedings they might bring, whether it's a winding up, for example, appointment of a liquidator, etc.
Okay, the things which you alleged, which your side alleged, and which you say the court pretty much accepted, are any of those things contrary to the Articles of Association?
Well, it would be
perhaps the notices. Or the absence of notice. We are not hearing you. I'm not hearing you.
No, I'm sorry.
Oh.
I'm just taking a moment to think.
Oh, I see. Okay, I'm sorry. I thought you were speaking.
No, apologies. I would have to double check the articles to see if it was contrary. I think, though, the greater concern is that, well, they should have, even just by company law, have had notice of these meetings and had an opportunity to attend and vote, particularly on something as critical as such a substantial increase in the share allotment. There was also, whether it's directly contrary to the Articles of Association, I would just need to take a quick look at the articles to say, but it's we say that the allegations of what happened, even perhaps if they strictly adhered to the articles, are part of a greater pattern to try and push these shareholders out and reaches the level of serious mismanagement or bad faith that then becomes a test at a later stage for the appointment of an inspector. So it really was the majority trying to use the process in a manner to achieve their own ends without giving, if I can say, due process or an opportunity to the minority shareholders here.
But Mr. Chair, suppose there was notification and they had turned up and it was put to the vote. They were minority shareholders, 35%, I believe. It would not have made a difference for outcome, right? Assuming everything went right. Okay, so your challenge is on the process. Your challenge is on your complaint is about the process.
Yes, that's correct. The court is very right on pointing out they did at the end of the day, at their highest, they held 35%. That's still a minority. This all could have been done and they still could have lost. And that's
in which event the medical school could, if due process was followed, could now be in the Cayman Islands, and they're properly so according to the memo and articles of association, etc. Right? So I think what the president, from what I understand anyway, I think maybe the president is asking, all right, so you get an investigator and the investigator confirms that there was no proper notification. And therefore, because of that, your clients did not attend the meeting and did not vote. And so the resolution was passed without their notification or participation in the vote. Yeah, I think what the president was trying to ask you is, all right, let's assume the investigator does that. What happens next in a very pragmatic way that can change the existing outcome? Does it sound in damages that benefit your clients? Can something be reversed? Can this be undone? Is it that this can be set aside? What is it? Because you do not have, as in the Canadian scheme, the oppression actions, etc., that are that minority shareholders enjoy, right?
Yes, so we don't have the same.
Yeah. So what would be your end game? Let's suppose you get the investigator in and the investigator confirms these facts. All you get is a report from the investigator saying exactly what the judge found to be true, right? What next?
Well, it could be, as the court mentioned a moment ago, a claim in damages, perhaps a claim to restore the assets of the company. We're in a situation here where we're, not to say we can't look ahead to there, but assets were moved out of the jurisdiction. The majority of shares were transferred into a new company that continues to operate a successful medical school, banking on, I would argue, the goodwill of the name of St. Matthew's. And so there may be damages to the companies, not just to the shareholder themselves. Perhaps there's a claim for derivative action in there that can be founded once there is a finding as to, and some more information as to what actually happened.
Okay.
So you're taking it one step at a time. Get the investigator, get the facts, and then on the basis of that, you would see what your options are.
Yes, and that's what the case law says. That's how you take it. It could very well be, and I'm not conceding this, but it could be an inspector is an appointed, the inspector goes in and says, no, this was all done properly. And then, but it's the shareholders, though they're minority shareholders, and though the Belize scheme isn't the same as the scheme in Canada, say, or in other Caribbean jurisdictions, they still have rights as shareholders. They still have rights to vote. They still have the right to certain information, and they've been denied all of that because of how the majority acted in this case. And so that's what they're seeking to have investigated, so they can, at a minimum, know what actually happened with their investment.
Counsel, I believe that the Court of Appeal explored that aspect of what next steps. And yes, they themselves came up with quite a few, including winding up the possible court proceedings to nullify the previous court order, which we still need to have some clarity on, or to bring proceedings such as a petition, they say, by a minority shareholder on the ground of unfair and prejudicial acts. So I guess there are options, but from what I understand you to be saying is that you first need to find the facts. You first need an inspector who can, under Section 110, bring forward certain findings of fact, because as I understand 110, that inspector has quite a few powers under the Act.
Yes, the inspector does have quite broad powers, which relate to and go to the purpose of the appointment of inspectors and the purpose of this mechanism in the Act. And yes, as the courts pointed out, the Court of Appeal did go through, as I mentioned at the outset, a number of options. Now, arguably, and my friends may argue because they've done this in their submissions, that, well, the appellants could still go and apply for a winding up, or they could seek the appointment of a liquidator. And whether legally they could do that, perhaps they can, I won't get into that, but they're doing it with both hands tied behind their back because they don't know what's happened. And so the inspector is there to do the fact finding and get them the information which we say they'd be entitled to as shareholders and to know what actually happened with their investment.
To add to my sister's list of opportunities available to the shareholders, wouldn't there be a right to personal actions for breach of contract? As you correctly pointed out, there are certain attributes that attend to a share, and one of these is the right to vote. There's also the right for the company and the directors not to breach the terms of the Article of Association. So it depending on what is discovered, personal rights may very well accrue, or personal actions may very well accrue to shareholders. But this is jumping the gun. I just wanted to draw this as another example of what may be available.
Yes, and I can't recall if I mentioned it. Building on those, perhaps dividends have been paid out and they have a cause of action to sue for payment of dividends that haven't been paid to them. We just don't know.
Yes, you need to proceed quickly.
Yes, I am mindful of the time, so I'll move through here. And so this, just to return, I was speaking about Section 110 of the Act, and I think I've addressed the purpose. I don't need to go into that any further. I will, and I won't spend time getting into the test, which I think both parties agree is the test is set out as Lopez, the good reason test. It's also set out in the statute. I will just note here that it's clear the test is fact specific, and the court is asked to look at this, the particular cases of the particular facts of the case before it. And we say this is something that the trial judge did and that the Court of Appeal didn't do when looking at the standing requirement. And so this brings us to the standing or threshold requirement in Section 110(1)(b), which would apply to this company, which says the court may appoint an investigator on the application of members holding not less than 1/10 of the shares issued. And the Court of Appeal preferred a plain language reading of that provision and said, appellants, you don't have 10% of the shares, you don't have standing, the analysis ends there. We say that in this case, a proportive interpretation is more appropriate, and that's exactly what the trial judge did. He didn't look just at how many shares the appellants held as of the date of application. He looked at why the appellants had those shares. As I mentioned earlier in my recital of the facts, in December 2000, before these acts of the majority, the appellants held 35% of the shares in the company. They would have passed the 10% threshold with no problem at that time. They also at that time had no need to seek the appointment of an investigator because they were engaged in the company. Dr. Sersland was a director. Dr. Sersland was engaged in the management and operations of the company. It was only after the majority took the act, starting with locking the appellants out of the company, subsequently bringing these resolutions, increasing the shareholding so significantly and allotting those shares. It was as a result of these direct acts, which themselves reduced the appellant's shareholding, that the appellants then had to come to the court for relief. And so we say the trial judge considered and applied the correct legal test in looking at section 110B and Lopez. He then considered and weighed the evidence on the circumstances and the particular facts of the case. And he accepted and preferred the applicant's evidence regarding the circumstances in which their shareholding in the respondent company was diluted. And the trial judge said specifically that these were the circumstances and some of the issues that the inspector would have to investigate. And so we say that looking at the purpose of section 110, the purpose of this remedy in the act, that the trial judge was correct in considering the circumstances which brought the appellants before the court. The respondent should not be able, as the Court of Appeal effectively lets them do. The respondents shouldn't be able to benefit from their own alleged wrongdoing. The respondents took steps that effectively diluted the appellant's shareholding and forced the appellants into a position where they can't come before the court on a strict reading of section 110(1)(b). So we say, looking at the purpose and the purpose behind the mechanism and the test, the trial judge was correct in taking the circumstances into consideration. And it's on that interpretation that actually upholds the purpose behind this remedy, and the Court of Appeal's approach effectively defeats that. And I will just point out, much like the Court of Appeal went through the various remedies that the appellants could seek and the types of remedies that could be sought following a report, the Court of Appeal identified the many seemingly merited items of complaints against the many actions of the majority shareholders. And so they did take notice of the situations. And so for those reasons, we submit the court erred in its interpretation of section 110(1)(b), and the trial judge's interpretation should be referred. So being mindful of the time, so I'll move on to the next ground, which is that the Court of Appeal erred in setting aside a discretionary decision of the court below. There seems to be no dispute between the parties that the court's power to appoint an inspector to investigate the affairs of a company is discretionary. And the parties, although we've cited to different cases, seem to be agreed on the standard of review for a discretionary decision. And so we submit that the appellate court ought not to interfere lightly with a discretionary decision. And if the court finds that the trial judge didn't err in its interpretation of section 110(1)(b), that was the type of decision where it was not so plainly wrong or so outside the generous ambit of discretion that the Court of Appeal should have interfered. So we say there were no grounds to interfere in a discretionary decision.
But their interference was not so much, am I correct, that their interference was premised really on the fact that they thought the threshold wasn't reached. They didn't get to whether the judge's decision absent that threshold issue was a reasonable or unreasonable one. Am I correct?
Yes, I think that's
or
a
you
fair.
find it difficult to disaggregate the two things?
They didn't in their reasons address whether it was reasonable and whether it fell within a reasonable decision, but because of the Court of Appeal's interpretation and simply saying, no, they don't on paper have 10%, this is done. We say it was within the judge's discretion and part of his exercise of discretion to look and consider those other circumstances. And so the reasons don't address it, but it can't be so neatly pulled apart there. We say there was
isn't your criticism really that the Court of Appeal erred in law in its interpretation of 110 and therefore fell into error because it used the shareholding at the date of the application, and that didn't take cognizance of the relevant facts, i.e. the diminution without notice, and prior to which they had 35%, therefore they crossed the threshold.
Yes, I would say that's our primary argument. And I think I would qualify perhaps the discretionary as a, perhaps not in the alternative, but our primary argument is, yes, they were wrong. They erred in the law and how they interpreted section 110 so narrowly.
But the Court of Appeal did not say after they made that point, and moreover, the discretion was not used properly. Isn't that so?
That's correct. They did not state that in the reasons. They simply said the threshold wasn't met. The
And
analysis.
that's where the case was decided as far as they were concerned.
Yes.
Okay.
And your response to that is that the threshold, as Mr. Justice Chamada says, threshold issue should have, or consideration of the threshold issue should have taken into account the fact that the very basis upon which the application was being made was to unravel the circumstances in which you are in a position where you have less than the threshold.
Yes, that's correct. The appellants
And in fact, the Court of Appeal agrees with your factual narrative.
Yes.
They don't disagree with the trial judge. They agree that there was, prior to diminution, there was a 35% holding and no notice. But their position is very simple. On an interpretation of 1101B, you have to calculate the shareholding at the time of the application. And nobody disputes. You don't dispute that at the time of the application, you only had 10% or less. So they never for a moment engaged the trial judge to, on any finding of fact. They simply said the date at which you calculate the threshold for the purposes of an application under 111(1)(b) is the date of the application. That's what it comes down to. And you say no, wrong. Wrong as a question of law, because it undermines the purpose of 1110(1)(b), or it defeats it. That was your language. It defeats the purpose. And that's it. That's what this appeal is about from your point of view, isn't it? Nothing more. Either if you're right on that, then we move forward. If you're wrong on that, well,
Yes, that sums up the case very succinctly. If we're right on the first ground, then, and that's why I say that's our primary ground. The others are included in our submissions and the way we've narrowed them.
So maybe if we read the submissions, we'll get the gist of those other points. Unless there's something that you really want to bring to our attention from those subsidiary points, I think that, sorry. Is there anything that you read that really stands out that you want to tell us about from these other points?
No, my lord has just pointed out the one point I just wanted to emphasize on ground 4 is that the Court of Appeal accepted all of the trial judge's findings of fact. And in fact, if there was one challenge in the appeal below as to facts and the weight of evidence, the Court of Appeal dismissed that. So I think that's the only point I have to make, being mindful of time and the court's comments. We'll rely on our written submissions as to grounds 3 and 4. And so subject to any further questions, those would be our submissions.
Okay. Thank you very much.
Yes, I thought also that you were, I'm sorry, President.
No, you go ahead.
Yeah, I thought that you were saying the moreover that my brother Justice Witt mentioned. You were taking us there to say moreover the Court of Appeal did not say that anything about the exercise of the discretion by the trial judge. And from what you were saying of the test and the case that you cited, the good reason test had been satisfied. So that is where I thought you were taking us, but thanks a lot.
That is, I will just point out, to be transparent, the Court of Appeal didn't engage on the good reason test. They said there was no need to, as you will have seen in that decision.
Yeah. Okay, thank you, Ms. Chiesa. Ms. Swift, are you able to proceed?
Grateful, Your Honor. I am prepared to proceed.
Yes.
Your Honors, I would like to briefly take the court through some of the facts that we think are relevant for consideration. Firstly, we'd like to point out that the alteration to the Memorandum of Association was conducted from January 2002. We are now in 2022, obviously, so this has occurred over 20 years ago. The company has not been operating in Belize since 2002. There was a query with respect to the court order that was entered January 2002 that confirmed the alteration of the Memorandum of Association. I believe it was, Your Honor, Justice Saunders had inquired whether there was any information in the record as to why there was a confirmation by a court order. In the affidavit, the fourth affidavit of Seferino Paz Jr., which is located at page 505 of the electronic record, he exhibits an affidavit of Michael Harris. And at page 524, paragraph 39 of that affidavit, Mr. Harris had provided an explanation as to why they sought confirmation of the alteration of Memorandum of Association. He states that he believed that it was required under the Belize law to obtain an order from the court to confirm such. There was also a query by Justice Rajnath Lee as to which provision this was required under. I note from the order that it says that the order was obtained under Section 8 of the Companies Act. And that section requires it states, subject to this section, a company may by special resolution alter the provisions of this memorandum with respect to the objects of the company. And it goes on to say that the alteration shall not take effect until and except insofar as it is confirmed by petition by the court. 8.3 states that before confirming the alteration, the court must be satisfied that sufficient notice has been given to every holder of the debentures of the company and to any person or class of persons whose interests will, in the opinion of the court, be affected by the alteration. So while we
was there evidence provided that such notice had been given?
My lord, sorry, Your Honor, I cannot say for certain because I have not seen that document, but I can only assume that given that the order was granted by the court was satisfied based on the evidence provided that sufficient notice was given. That order has not been set aside.
Ms. Swift, then, is it that the objects of the company were being altered? So that,
yes.
So that is what the court gave its stamp of approval to, so to speak?
Does
it have anything to do with the alteration of the share capital then?
My understanding was that it did include alteration of the share capital because it had to alter the increase from 550,000 to 1 million.
So, Ms. Swift, then the question remains unanswered then. Under what provision?
Because Section 8 speaks to getting the of altering the objects of the company, altering
yes,
the
Your Honor.
memorandum with respect to the objects of the company. And I don't know if that is the application that was being made. the special resolution, if did the special resolution alter the memorandum with respect to the objects of the company?
It did alter because I believe at the time the company only had 3 objects and they had to alter it to increase the finance, yes, and make it a more profit gaining venture.
But the court's imprimatur was not required for the expansion of the share capital, only with respect to the alteration of the memorandum so far as the memorandum related to the objects of the company.
Reduction.
From my reading of Section 8, I would agree with that, Your Honor.
Yes.
President, is there any way that, yes, President, is there any way that Ms. Swift may be able to assist us in getting copies of the relevant documents that gave rise to that court order? I think that would be most helpful, at least to me.
Yes, they really should have formed part of the record. To just brandish the order without the application that yielded the order and the evidence that supported the application does not give a wholesome picture of what lay behind the order.
And especially the affidavit in support, because the affidavit in support, one assumes, would have narrated facts, because the resolution came before the application to the court, correct?
Yes, that is correct, Your Honor.
Right. So one assumes that if you're going to court, following a resolution to get confirmation of something, under the belief that you need to come to the court for that, imprimatur, as the president has expressed it, that the narrative in the affidavit would have set out, and whereas by resolution at a special meeting convened and so, and would have said in it, no doubt, that the procedural requirements of the articles would have been satisfied, for example, notification, etc. So the affidavit would have been very interesting. But you put in the order, it seems, from what we were told. Your side put in the order. You're for the company. So therefore, these are documents under your power and control, or would have been under your power and control, or your client's power and control, correct?
That is correct, Your Honor.
Yeah.
I believe this should be on our file at our office, so I will try to obtain the document and provide it to the court.
Very well. And of course, to the other side.
Yes, definitely. We'll do that.
Yes, go ahead.
But if such an order is given, does the judge not have to establish that there was sufficient notice to other shareholders? Did that happen?
From my understanding of Section 8(3)(a), there is a requirement that the court must be satisfied that there is sufficient notice before approving the alteration of the memorandum.
Except Ms. Swift. Ms. Swift, there's a proviso, you see. There's a proviso to dispense with notice, and that's why the affidavit is very interesting. There's a proviso at the end of Section 8(3), isn't there?
Yes, if there are special reasons, the court may dispense with the notice.
Yeah, exactly. So the point is that we must not rush to assume that the notice issue is foreclosed by the fact of the order. We just don't know until we see, as the president asked very early on about the application, and I think he may have, but certainly I have also added the evidence in support. Both, I think, are important.
Got it, Your Honor. We will, as I mentioned before, seek to get a copy of those documents to the court and to my learned friends.
Sure, thank you.
You're welcome. The next relevant date we say, Your Honors, is the 29th of December 2005, when Mr. Paz and Mr. Sersland had filed claim 486 of 2005. That document is located at page 262 of the record. And in that claim, the appellants had seek orders and declarations challenging the increase in the share capital and the allotment of shares. That claim was struck out in July of 2008. And it was also appealed to the Court of Appeal, where the decision was affirmed. We note that the appellants have taken the position that that matter was not determined on the merits, because there was an issue as to whether procedurally they should have gone by derivative action. However, we say that the appellants had an opportunity, and they did take that opportunity to challenge the increasing share capital and the allotment of shares, and they were unsuccessful.
Ms. Swift, may I just clarify something? Are you suggesting this is the abuse of process point, right? This is an abuse of process argument, that the instant action is an abuse of process because the appellants raised the issue, had an opportunity to litigate it, and the matter was has been dealt with. So therefore, this action is an abuse of process. Is that where this is going?
No, Your Honor,
No.
That's not where I was going.
All right, go ahead then. Sorry.
Where I was going was that these issues have been ventilated before the court. Mm-hmm. The allotment of shares, the increase of share capital, it has been ventilated by their attempt to file this claim that was unsuccessful.
Counsel.
And therefore what?
And therefore,
even if that is so, therefore what?
Therefore, the share capital that stood at the time they filed their claim in 2013 is the appropriate share capital for consideration.
Sorry, counsel, if I may.
Yes, Justice Burgess.
Yes, you said that that matter was resolved. Wasn't in the 2005 action? Wasn't that dismissed on the basis that a derivative action had to have the support of the company general meeting, and no such support was given? A meeting was called, but there was not a vote to vindicate the rights of the company pursuant to a derivative action. Isn't that the case?
Yes, that is the case, Justice Burgess.
So how can we say then that they had a chance to vindicate their rights, which they're now asserting? How can we say that?
I don't have a response to that as yet, Justice Burgess.
Fair enough. If you do, you can share it with us.
Grateful. In 2011, there was a further matter filed by the appellants, the notice of originating motion, in which they sought a declaration that the affairs of the company be investigated and also an order appointing an investigator. That claim was withdrawn in February of 2013. And then in September of 2013, they filed the instant claim, seeking once again the declarations from the claim of 2005 and the claim of 2011. The decision from Justice Abel was, of course, delivered in 2015, in which he granted the application for the appointment of the inspector. Our position, Your Honors, with respect to the decision from Court of Appeal is that the court took the proper approach in applying a literal interpretation to Section 110. The requirement was and is that you must have 10% shareholding in order to bring an application under that provision.
At what time? Does the section speak to at what time?
It does not speak to at what time, but I would think that it's at the time of the application, Your Honor.
Well, but that begs the question. A literal interpretation simply says that the appointment of an inspector under B is for members holding not less than 10% of the shares issued. It begs the question, in a factual context, at what time? Consider a simple hypothetical. If a person had 10% and a majority reduces that, let's assume it is an unlawful reduction. I'm not suggesting that this is a pure hypothetical. Reduces that. They had over 10%, is reduced to below 10%. Then they cannot, in your argument, qualify under 110B. But the whole point was that before the reduction, they had crossed the threshold. So is it that, in your opinion, given that 110(1)B does not say when, I don't even know if it's a literal interpretation, because there is not, if the section said, in the cases of on at the time of an application, if it said that, well, then that's a literal interpretation. I agree. But those words are not present. There is nothing in this section that tells us at what point in time. So why do you argue on your first premise? Why do you argue that on a literal interpretation, this must mean at the time of the application? What in this section says that that is a literal interpretation? Forget about purposive and everything else that we were told earlier. On your argument.
Well, Your Honor, I would say that the section is speaking in the present tense because it says having a share capital. So at that point in time, it's a share capital that you have.
Okay, so
also, Your Honor, if it is the court question was, the hypothetical was if the share capital was unlawful.
Let's stay with the literal interpretation, so that you would say that the word having must mean in this section at the time that the court appoints, or that the application is made for the appointment. That's
at the time the application, yes.
Right, okay. So you rest that entire argument on the word having for your literal interpretation argument. Is that it? Is that the extent of it?
Yes.
Okay, good. Thank you. Yeah. Okay, yeah. That's fine.
Sorry, Your Honor, I was about to say that the court, if it is that it's not the present tense and the hypothetical that the court proposed, which is the share capital was unlawfully reduced, I would think that the court would have to go into an examination as to whether or not, and a finding as to whether or not it was unlawfully reduced before making the decision on the
To
10%
appoint an inspector to investigate whether it was unlawfully. You remember, the point is that you want to, the gravamen of this case is diminution of shares to below the 10% threshold. And the investigator is to investigate, the inspector is to investigate that, among other things. So what you were saying is that the court should undertake a fact-finding mission to determine this question of diminution. Yes? All right, fair enough. In this case, what did the first instance judge and the Court of Appeal conclude on those facts? What did they conclude? Is Ms. Shazier correct when she told us in her opening that both the first instance judge and the Court of Appeal found as a question of fact, and she goes further to say on the affidavits, it is admitted or in law to be deemed admitted that without notification, shares were diluted below 10%, from the 35% to below 10%. Do you say that those findings are fact by the first instance judge of the Court of Appeal? That's erroneous, that's not accurate?
I would say I agree with my learned friend's submission that the court did find that it was reduced without notice to these shareholders.
So does that satisfy your fact-finding inquiry? For the purpose of this application?
I would say no, it does not.
Why not? If they say without notice you diminished it, and you don't deny that, and it is an admitted fact, what inquiry should they engage? Are we on pleadings? Is a court supposed to investigate facts that are deemed admitted?
No, we would. No, Your Honor.
No.
If it's not disputed, then there's no need to investigate it.
So why should the court in this case have undertaken inquiry into those facts when they were admitted? The only question for the court was on these admitted facts, how does that impact the 110(1)(b) test? Your answer is very clear now for me anyway, that because of the word having, it's present tense at the date of the application, and therefore the undisputed evidence is they had less than 10% on in 2013. And Ms. Shazier accepts that. And that's the long and short of it. Yeah?
Yes.
Okay, good.
It's not so much the word having, it's the word holding. Am I correct?
Sorry. No, having.
Yes.
Miss Swift said having. In the case of a company not having a share capital. But that's what we were told, President.
Yeah, but I think it's the members, the applicant should be holding greater or less than 1/10 of the shares issued, as distinct from the share capital of the company as a whole. Am I correct?
Yes, it says on the application of members holding not less than 1/10 of the shares.
Right.
Issued. But that's holding or having.
I'm sorry. Yes, holding would be the appropriate word and not having.
Yeah, but it doesn't change your point.
That it's present, that it has to be that it's present tense, meaning that they have to hold or have that amount of shares at the time of the application.
Yeah.
Respectfully, Your Honor, if it is that application is granted on the basis that the investigator may or the inspector may or may not find that it was unlawfully reduced, then at the end, if it is that it's confirmed that it was appropriately done, meaning that these shareholders do have less than 1/10, then there's no purpose to the provision. It would mean that the application was granted to someone that did not meet the requirements of 1/10.
That is a good point, but there is a corollary to that, which is that if the very purpose for which the applicant desires the investigation is to investigate what they consider to be an irregular diminution of their shares from 10 or in excess of 10% to less than 10%, and your argument holds, then it means that the court would deprive them of the opportunity to have investigated the circumstances which would have established that, in fact, they would have met the threshold. So you look at both arguments, because the first alternative that you said is also true, that if you grant the application to a person who has 9% of the shares, but who is complaining about the fact that they were unlawfully deprived of being able to claim that they held 11%. And the investigation turns up that, no. They only had and are only supposed to have 9%. And therefore, we all went down, this trail of application and investigation in vain. And this is the value of the literal interpretation as you advance. That is also true, but there's a corollary to it. So one has to weigh up both things.
The problem for me is that your position sounds a little bit like the man who murdered his parents and then asked for clemency because he had become an orphan. He put himself. It's difficult to use that argument if the accusation is that you saw to it that the number of shares became much less than 10%. It creates a difficulty.
I would admit that there is some difficulty with the evidence, Your Honor. The issue in relation to the notice was dealt with in evidence in other proceedings, which are exhibited to the affidavits in these proceedings, but they weren't included directly in the affidavit in response to the claimant's case. It was actually included in the claimant's affidavit. So there is some difficulty. Our position has been that sufficient notice was provided, but of course that is not contained in our evidence in response. It's only contained in the evidence from different proceedings, which is in this record, but not directly in response to the claim.
Help me here, Counsel.
Yes, Your Honor.
What is your position in relation to the appellant's argument that Section 110(1)(b) is a shareholder remedies provision or grants a remedy to shareholders? What is your is that? Do you share that view of Section 110(1)(b)?
No, Your Honor.
So how should we interpret it?
It is specifically a provision that allows only shareholders with at least 1/10 of the shares or 10% to obtain an order for a fact-finding mission.
Isn't that a minority? Isn't that a minority shareholders provision, as the appellants are arguing?
Well, yes, it does provide some remedy for minorities, yes, provided that they have 1/10.
And if this is the case, wouldn't you be surprised if Parliament would allow, as my brother Jamadar has pointed out, would allow the majority shareholders to pursue mechanisms to ensure that the minority shareholders' holding is diluted to way below 10%? Do you think Parliament could intend, if you accept that this is a shareholders' remedy provision, wouldn't Parliament really be shooting itself in the foot if it allowed, so to speak, if it allowed the majority shareholders, because it's attempting to protect the minority against the majority, but at the same time is allowing the majority to deny the minority the very remedy that you've admitted exists in Section 110(1)(b). Isn't that slightly absurd? At least?
Your Honor, in my view, if it is that Parliament's intent was to provide these remedies that the other jurisdiction now have in their legislation, that Parliament would have legislated for that.
But Ms. Swift, let's not rush to see what other people did. I think that we have to look at this legislation, and as our brother has asked, what is we always ask this fundamental question when we have to do statutory interpretation: what was the intention? And what our brother has put before you, and I think you have agreed, is that it is to provide a remedy for minority shareholders. So I think before we rush to look at what somebody else did and if they wanted, I think just on its own terms, if they intended to provide a remedy for minority shareholders, would it be contrary to that intention? Would it undermine that intention if majorities could, by resolution, defeat rights? That's the effect of what. How does that configure with the intention? Is that not what our brother is asking? Does that not seem to be contrary to the intention? You know, in this section, this is only to just investigate and find facts. This is not an oppression remedy. This is nothing like that. Some things may come out of it. We had a little conversation about that. This is simply to investigate, and they put a threshold because they don't want a person with 1% to come and start up a whole investigation. So they put a threshold. They say, all right, you must have 10% at least. But if you cross that threshold, well, then you have what the Parliament is saying is, well, you know, when you cross 10%, you've reached crossed that threshold to sort of earn the opportunity to come to court, provide evidence. Good reason is a test. We all agree. Good reason why. And it's filtered through a court. Why there should be an inquiry. Just can't come willy-nilly. You don't have a right per se. No, you have to move the court. And if you satisfy the court says, okay, yes, I am satisfied that we should allow this. What comes out of it may turn out to be of no practical value. But what it may protect is what our brother has been asking you here. That is to say, some form of statutory, albeit a lot different from the other jurisdictions, some form of statutory protection for minority shareholders.
I hear what Your Honor is saying. I just have a difficulty with the reading that if you can dispute whether or not you have the 1/10, meaning that there isn't a firm if there isn't firm evidence that you have 1/10, you can dispute that there's a possibility that you had 1/10 at some point, or advance that you had 1/10 at some point, then you can obtain an order under this
Well,
provision.
I don't think the facts of this case suggest that. The facts of this case suggest that, and you don't dispute it, that they had 35% at a certain point in time.
Yes.
What they assert is without notice to them, it was reduced. That is the nub of the thing here. It's not that I don't think the legislation is saying that if you had 30%, suppose everything was done and there was no challenge, and there could be no challenge to the due reduction in the shareholding, then I don't think we would be in this conundrum. It wouldn't arise. This conundrum arises because of a fact, which is that prior to the without notice diminution, they had more than 10%. And the point taken that therefore you don't qualify under this section. That's all.
And it is those actions that they asked to be investigated that brought down that number or that percentage of shares that they had. So it's not that they once had 35% and then but for all kind of reasons that went down to less than 10, and then something happened they want to investigate. No, that the 35% was there right before things happen that they say need to be investigated. So it is very fact particular.
Sorry, I don't know if the court has any other question in relation to the interpretation of section 110.
No, you may proceed.
There was a question by Justice Burgess with respect to the quote from Justice Denning and whether or not it was based on the 1908 Act. I note at page 910 of the Record of Appeal, there's actually a reference to the order being granted under the 1948 Act, which is this last two lines on that page. With respect to the discretionary point, as my learned friend indicated, we are in agreement with respect to the test. However, it is our submission that the court did not make a decision on whether or not there was good reasons or sufficient reasons to grant the Court of Appeal did not determine that issue. The Court of Appeal made a decision on the interpretation of section 110 and found that the court erred in granting the application, having been satisfied that there's a possibility that the shareholders hold 10%. The Court of Appeal found that the 10% threshold was a requirement before granting the application or going on to consider whether there are sufficient reasons or good reasons. So we say that the Court of Appeal did not err in overturning the decision because the Supreme Court erred in law, and that was a legal issue as to whether or not the 10% was required and had been met. We addressed the other points in our written submissions. They're pretty short. I don't think there's any need to repeat them unless the court has any specific questions.
Tell me something. A shareholder who complains that things are happening in the company, they have substantial shares in the company, things are happening behind their backs that are to their disadvantage. What remedies do they have under the law?
Things are being done by the company.
Right. By other shareholders, by directors, and without their knowledge, without their consent, agreement, and these things are to their disadvantage. They could apply for just and winding up, I suppose. They could do that?
Yes.
Okay.
I'm not certain if they would be able to also seek a declaration from the court. That I'm not certain about.
A declaration that what? That these things are unlawful?
Yes. Perhaps that
okay.
the shares were unlawfully diluted.
Okay. Perhaps my question needs to be filled out a little bit more. They suspect things are happening. Well, not that they suspect. They know that things are happening, that the things are disadvantaging them, but they do not have the evidence to place before the court in order for the court either to wind up or to right whatever wrongs might have been committed. What options are available to them?
To obtain evidence?
Yes, to substantiate.
Yes.
What
sorry, I'm asking myself out loud. To obtain the evidence, Your Honor, I would think that the only option other than what's available at the registry or requesting from the company the documents, the only other option legally to just obtain information would be through Section 110, if it is that you're proceeding by court action.
Yeah, okay.
So in summary, our respectful submission is that the Court of Appeal decision should not be overturned, that the appellants did not have the requisite shareholding to advance the application or be successful in the application before the Supreme Court. And those are our submissions, unless there are any questions from the court. I believe I answered every question that was posed to my learned friend. And as indicated, we will provide the documents in the 2002 petition.
Okay, thank you. Thank you, Ms. Swift.
You're welcome.
Ms. Chiesa, do you have anything to say in response? You're on mute.
Yes, I have just, I think, 3 very brief points. So first, to come back and answer the question posed by Justice Rajanathan Lee about Section 49 and whether there was an equivalent provision which requires the court's blessing to significantly increase shareholding. We reviewed the Act and we can't find a similar provision. Then in response to Justice Burgess's question regarding the Lord Denning quote, I unfortunately haven't been able to pull up a copy of the original case the quote comes from during my friend's submissions, but would be happy to find and submit a copy of the case directly after the hearing, if that would be of assistance to the court. And then just to address my learned friend's submissions at the outset, when she was reviewing the facts and she stopped to emphasize the passage of time between when the articles were amended and today's court hearing. I would simply add on that point that the appellant's position is that the respondents shouldn't be able to benefit from the passage of time to avoid any responsibility or any obligations to disclose under an inspection, if that's where the court ultimately decides. And finally, the court asked, I believe it was the president who asked earlier in the submissions, whether there was case law where minority shareholders had used Section 110 as effectively as a shareholder remedy. And having double checked the case law, I would point the court to the Belize telecommunications case that is in our brief of authorities. And this was an application by 6 applicants who were minority shareholders for a Section 110 investigation. Now, in this case, the investigation itself wasn't opposed, so the case deals more with the scope of the investigation, but it is an example of how the remedy has been used by minority shareholders. And so, subject to any questions from the court, those are my reply submissions.
Okay, thank you. We will take a short recess, and we invite you to remain on the call. You can turn off your mics and your video, and we'll get back to you very shortly.
President, I'm not seeing Justice Witt. Is he back?
Yes.
Oh,
Yes, right. Okay, Council, we will reserve our judgment in this matter. Ms. Swift, we will look forward to those documents by Monday.
Your
Is
Honor,
that reasonable?
I just checked our server. It's not on our server here, so we may need to get it from
go to the
council
court?
before or from the court. So
You want a little bit more time?
By Wednesday?
By Wednesday? That's fine. Okay.
Grateful, Your Honor.
Yes, so you get us those documents by Wednesday, and the court would reserve its decision in this matter. Thank you, Council, for your submissions. And Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Madam Justice Rochnetly. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamada. Thank you, Council, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank
Thank
you.
you.
Good day.
Good day.
Well,